Okay, it looks like everyone who's registered has arrived. First of all, thank you so much, everyone, for attending. My name's Harriet Wessel. I am on the International Committee for HYLA this year. I'd just like to take this opportunity to welcome you all to this international CLE. And I'd also like to take the opportunity to thank all our partners that have come together to make this program happen. So the New York State Bar Association Young Lawyers Section, gosh, that was a mouthful, the Austin Young Lawyers Association, the San Antonio Young Lawyers Association, the Fort Bend Young Lawyers Association, and the University of Houston as well. We have actually, all the way from Texas, we have managed to make this a worldwide reach. I understand we have people tuning in from Paris and obviously Ukraine. And so we're really grateful to everyone who's here today, both speaking and also who's tuned in from across the world. So thank you so much for joining us. Without further ado, I'm going to hand over to DeMaggio, who's going to moderate our panel today. Just one more housekeeping item. Please remember to self-report your CLE. We're going to put the code in the chat about halfway through the program. And if you have questions, please feel free to put them in the Q&A and they will be addressed at the end of the program. Thank you.
Thank you, Harriet. Good afternoon. My name is Anna DeMaggio. I'm a Ukrainian American born and raised in Zaporizhia, Ukraine. I received my Master of International Law degree from Kiev-Shevchenko University, Institute of International Relations. I currently live in Houston, Texas, where I work as an in-house counsel at a construction company called ORION Group Holdings. My history with HYLA goes back a few years ago when I was chairing a professional development committee, and I'm currently a fellow of the Houston Young Lawyers Foundation. I'm excited to present today's panel, who will discuss the current issues of international law in Ukraine in the context of the war of Russia against Ukraine. And I'm honored to introduce the panelists. I'll introduce Mykola Gnatovsky, the judge of European Court of Human Rights and professor of international law at the Kiev National Shevchenko University, Institute of International Relations. Judge Gnatovsky, we're unable to hear the round of applause at the webinar by way of doing this Zoom conference call, but HYLA, in collaboration with all the state bar associations and all of us, are extremely grateful for your presence at this panel today. We appreciate it. Thank you for joining us from Strasbourg, France. Anton Korynvych is the ambassador at large of the Ministry of Foreign Affairs of Ukraine, who also served as the permanent representative of the President of Ukraine in the Autonomous Republic of Crimea. Anton was also an agent of Ukraine before the International Court of Justice in the matter of the allegations of the genocide. And he also is an associate professor of international law at Kiev-Shevchenko University, Institute of International Affairs. Anton, thank you so much for finding time to join the panel as well from Kiev, Ukraine. The next panelist, Maria Bezdenezhna, is the legal advisor of the Ukrainian Embassy in Hague, the Netherlands. In her day-to-day work, Maria analyzes legal agreements for Ukraine and advises Ukrainian government on various international law issues. She's actively involved in Ukraine's representation in various international organizations, and she communicates with the International Court of Justice, the UN, the European Commission, and other international institutions. Maria, thank you so much for joining us from Hague, the Netherlands. Alexander Gudko is our next panelist. Alex is an international disputes lawyer at Covington and Burling in New York, who represents state-owned and private businesses in Ukraine in their disputes with the Russian Federation. For example, Alex represented Ukraine's state-owned oil and gas company called Gnatovsky in an investment arbitration arising from Russia's unlawful expropriation of property and assets in Crimea. Alex's firm helped the client obtained a $5 billion award against Russia. Alex, thank you so much for joining us from New York. So my first question is to Judge Gnatovsky. Judge Gnatovsky, I know you're very busy, you don't have much time, but we appreciate if you can stay for the panel as long as you're able to. Could you please tell us about the pending cases on the docket of the European Court of Human Rights that involve Russia's alleged atrocities against Ukrainian civilians and the military personnel?
Yeah. Good morning, everyone, and thank you very much, Anna, for putting this panel up together. And it's a real pleasure to see you after so many years. And also, it's always a pleasure to see my friend Anton and my friend Maria and also Alex, whom I haven't seen for quite a while. So it's a very, very good opportunity. Thank you very much for that. And many thanks to everyone who's joined today for this panel, for your interest in Ukraine and international law and in all these matters that we are going to be discussing today. As Anna has mentioned, I will probably not be able to stay you throughout the whole panel, but I'll try to stay for as long as I can. And you are very welcome to put any questions you might have in the chat, and I'll try to respond either when I have the floor orally, or I can even type in something in the chat as long as I'm here. As Anna's mentioned, I'm a judge at the European Court of Human Rights, which is a regional human rights court in Strasbourg that has a jurisdiction comprising almost the entire European continent. Russia was a party to the relevant convention, to the European Convention on Human Rights, until 2022. It was expelled from the Council of Europe in March 22, and that meant automatically that half a year later it ceased to be member, to be party to the convention in September 22. Up until that time, the court still has jurisdiction to look into cases that involve various alleged violations of the European Convention on Human Rights, also related to the armed conflict, to the war of the Russian Federation against Ukraine. And there's two categories of such cases, and this is also something that is typical for the European Court of Human Rights. It is first and foremost the court for individuals. It's a court where any person, any individual, but also any legal person can, if it's a non-governmental organization, of course, not a state structure, can sue any European state, any of the 46 and previously with Russia 47 European states for alleged violations of the European Convention on Human Rights. Now, there are several thousands of such cases against Russia. I would say the current figure, it's very difficult because it's rather fluid, but the current figure would be somewhere in the region of 4,000 to 5,000 individual cases, I would say. There's also cases that invoke also possible responsibility of Ukraine. There's a strategy that many lawyers pursue whereby they file these applications against both states because both states have some degree of responsibility for upholding human rights even during the armed conflict. There is the second category of cases, which are the so-called interstate cases. And in interstate cases, states parties to the European Convention, they can go to the court against each other, alleging violations of human rights that are taking place at a systemic level, the so-called administrative practices. And the courts sue on behalf of themselves. They are not protecting their own rights. They are protecting rights of individuals. So they are sort of advocates for the individuals. And currently, there are 4 ongoing cases at the European Court of Human Rights relating to Russia's war against Ukraine. The first case concerned the events in Crimea, and it has just been completed on the merits stage on the exactly 1 month ago, interestingly, on the 25th of June. this year, the European Court of Human Rights delivered its judgment of the Grand Chamber, the biggest and the most solemn formation of the court, on that case, and it's a unanimous judgment, which is unique for the European Court of Human Rights for interstate cases, finding violations, multiple violations, and grave violations in the form of administrative practices by the Russian Federation in the context of its occupation and an attempt to annex Crimea. And this spans across almost every right, or many of the rights that are enshrined in the European Convention and Human Rights and protocols there too, such as starting from the right to life in the context of enforced disappearances, for example, the prohibition of torture, but then going to matters such as private property and so forth. So and discrimination, of course. So that is the case that has been decided on merits. However, this is not the end of that case, because the court reserved the issues relating to compensation to the next stage of the case, and the applicant state, Ukraine, will have to calculate and to formulate its claims under Article 41 of the European Convention on Human Rights, that is on the so-called just satisfaction, meaning compensation money. The second case, the biggest case, the so-called big case, its official name is Ukraine and the Netherlands versus Russia, with 26 other European states intervening. So it's a major case that started as a case about the events in 2014 and 2015 in the eastern regions of Ukraine, in the so-called Donbass, in Donetsk and Lugansk regions of Ukraine. Then it was filed by Ukraine. Then the Netherlands filed an interstate application concerning the downing of the MH17 flight in July 2014. And then Ukraine also filed an application that concerned the events following the large-scale invasion of the Russian Federation to Ukraine that started on the 24th of February 22. And the Grand Chamber of the European Court of Human Rights decided to merge those cases. So they are examined together, all these applications, in one big case. The court has delivered its admissibility decision, found most of the complaints made admissible, and the court is currently at the merits stage. It has held the hearings, and it is working on delivering a judgment on merits in that case. There's two more cases. There is a relatively smaller scope case concerning the detention of Ukrainian seamen in the Kerch Strait. And there is also a case which was filed by Ukraine against Russia about the alleged administrative practices of political assassinations abroad. And those two cases are pending. So now the resources of the court, they are mostly concentrated on those cases. So once the two cases, the Crimea, which has already been decided on merits, and the big case, Ukraine and the Netherlands versus Russia, are decided, the court will be able to deal with thousands of individual applications, because in the interstate cases, it establishes the general context, it establishes the main time frame, the events, which state had jurisdiction over which events, and which state is responsible, and so forth. So that will help the court expedite the treatment of many other cases. So largely, this is how the docket in Strasbourg looks like now.
Wow, it looks pretty busy. Could you please elaborate specifically about that recent ruling that you mentioned on the merits of Ukraine against Russia regarding Crimea, and what the implications of that ruling are? And also, if you could mention a few words about the enforcement of that ruling. What is going to actually happen after the ruling takes place?
Yeah, absolutely. Thank you for these questions. I'll start with the contents of the judgment. Of course, the judgment itself is almost 400 pages without annexes, so it's rather difficult to summarize it in a few words. But as I said, it covers all the complaints that were filed by Ukraine concerning Crimea. And it's a crucial judgment also for those who are interested in international law, because it's the most elaborate judgment on the matter of human rights during belligerent occupation. So it really solves many issues on the interplay between the rules of international humanitarian law, the law of armed conflict, and the rules of the human rights law. So that in itself is very remarkable. But in more practical terms, there's important findings of the court. For example, one of the most striking ones, I think, and I already see from the academic commentary that this is the case, is that because being an occupying power, the occupying power in Crimea, the Russian Federation didn't apply the law of belligerent occupation, the law of armed conflict, as it should have, but instead claimed that Crimea had been annexed to the Russian Federation. It did not apply Ukrainian law in Crimea, and it also did not allow Ukrainian courts to operate in Crimea. Instead, it substituted them by its own courts. And the European Court of Human Rights held that due to such a unprecedented violation of the basics of international law and international law of belligerent occupation, the operation of Russian courts in Crimea cannot be considered as compliant with the requirements of the European Convention on Human Rights, namely Article 6. So it is not a tribunal established by law. This is what the European Convention on Human Rights requires, which means that any acts, any decisions of those tribunals are null and void. And that's a big thing. And then with a lot of consequences. Then in terms of enforced disappearances, there's been a very clear statement that it is not so much about the actual figures of people who remain unaccounted for, but it's rather about the practice of disappearing people. Some of them are found later, some of them are never found, but the general climate of fear and the general climate of persecution that existed allowed the court to say that there was such an administrative practice. The court is also very clear about the discrimination, the policies against the Crimean Tatars, and I think that this is the judgment that sets things right, because they were a little bit obscure after the judgment of the International Court of Justice in the case on the application of the Convention against for the elimination of all forms of racial discrimination. So that's I think that's a major thing. Now this is about administrative practices, and again there will be individual cases that will be based on these findings. Now regarding the implementation. Well, the European system of the protection of human rights, the Council of Europe, the European Court of Human Rights, this is, so to say, a club of civilized states. No one forced states to ratify those treaties. No one forced them to submit themselves to the jurisdiction of the European Court of Human Rights. And as long as Russia did so, it is legally obliged to execute the judgments. If it doesn't do so, this is a political matter that will have to be decided by political bodies, political mechanisms. And that is the question to the European states. And actually, the European Convention on Human Rights says that it is not the court which supervises execution, but this is the Committee of Ministers of the Council of Europe. And there are mechanisms to do it. I mean, it will also largely depend on the willingness of the relevant states and on the legislative basis that they may create for that, and on the decisions of their courts. But in principle, they can go after Russian assets in those countries. And execution of the European Court of Human Rights judgments is also potentially a reason to do so. But again, that would very much depend on the individual action from different states.
Mm-hmm. And you mentioned that it's important to make sure that the responsible parties are held accountable. Do you think you could also dwell a little bit on why it's important from the position of Ukraine, and I think from the position of the international community, to ensure that the Russian leadership and officials that violate international law ultimately are held accountable for the atrocities committed?
Well, first of all, it's important to understand that Ukraine and its allies, they rely on law. Their actions are lawful. They are on the right side of law, of international law as such. And there is a clear legal basis for Ukraine's self-defense, individual self-defense, but also collective self-defense. International law authorizes any state which is willing to help Ukraine to do so, because Ukraine is defending itself against armed aggression, unprecedented armed aggression in Europe since the end of the Second World War. The very important point. But then the question of impunity is also crucial. The injury done not only to Ukraine, the injury done to the international order, based on international law, is such that we cannot simply step over that and say, well, that's the right of the strong, might is right, and we just carry on. This can only be remedied via the application of international responsibility, via state responsibility, but also through the mechanisms of individual criminal responsibility. And the crimes involved, they generally know no statute of limitation, which means that they should be pursued for as long as the suspects are alive. And the only way to restore international law and order globally is to insist on accountability.
And Anton, I think you and Judge Gnatovsky were working together on a project in Ukraine that could assist with that purpose of restoration of international law and making sure that the government officials who are at fault take responsibility for their actions. Would you like to share a little bit about that project and what it did and your thoughts about it?
Yeah, thank you very much, Anna. It's of course a big pleasure to be here today with you and to talk to you from Kyiv. And it's a big honor to talk after Mykola, of course, after Judge Gnatovsky, and it's good to see all the people whom we haven't seen for many years, if I may say so. So I also hope that we will have a fruitful discussion, but I must admit that there may be some energy shortcuts in Kyiv due to electricity problems caused by Russian critical infrastructure attacks. So please be aware of that. So yes, we worked, and I must admit we currently work. Maybe Judge Gnatovsky does not because he's now in the ECHR, but Ukraine's government works on the project of establishment of the special tribunal for the crime of aggression against Ukraine. So this is this additional complementary mechanism, which we believe is important in order to ensure the full and comprehensive accountability for all the Russian violations of international law which take place in Ukraine. So the project is alive, the project is moving on, and we do already have some good interim results, provisional results, and I'm happy to share them with the audience. So what is the reason of establishing this tribunal? The reason is that Ukraine actively and effectively since 2014 uses each and every possible international legal instrument and tool to get Russia and Russian citizens to accountability to all the violations of international law they caused and they committed in Ukraine. It is International Court of Justice, European Court of Human Rights, International Criminal Court, International Tribunal for the Law of the Sea, international arbitrations, and many more. But there are two gaps for which there are no international mechanisms currently existing. So there are big two accountability gaps, loopholes, which we are currently, I mean Ukraine's government and our international partners, which we try to fill. So one deals with the compensations and the establishment of the international compensation mechanism. And the second deals with the establishment of a tribunal which will be able to exercise jurisdiction over the crime of aggression. The crime of aggression, which is a leadership crime of initiating and waging an illegal war of aggression. And of course, you are well aware that the situation with Russian full-scale invasion in Ukraine and Russia sections in Ukraine since 2014 is being recognized as aggression, in particular in the resolutions of the United Nations General Assembly. So the idea is to establish a tribunal, international one, which will have jurisdiction only over one particular crime, crime of aggression, because other co-international crimes like crime of genocide, crimes against humanity, war crimes are covered by the jurisdiction of the International Criminal Court. But we do believe that it is important to have a tribunal for these particular crimes, a crime of aggression, as it is a root cause of all the crimes committed by Russians in Ukraine. If it was not the crime of aggression against Ukraine, not a single war crime would have been committed in the territory of Ukraine. Before the Russian aggression, before 2014, we didn't know what is a war crime committed on Ukrainian soil. So that is why we work on the establishment of this tribunal. And I think that currently we have several interim provisional important results on this track. First of all, we gathered a core group of states and not official gathering of legal advisors of currently 41 states participating, including all the G7 states on board. Within this core group, we discuss legal and technical issues, how to establish a special tribunal, how to do this. And this is a big step forward, because when the project started in March and April 2022, and of course Mykola may recall this well, there were a lot of comments like, you shouldn't be doing this. This is impossible. Just use what you have, and you don't need to establish anything else. So the question now is not that we don't need the tribunal, the question is not if, but how. So how to establish the tribunal, how to make it possible. So I think that the establishment of the core group and its effective work, I think, is a good interim provisional result. And the second result, I would say, is the establishment and work in The Hague of the International Center for the Prosecution of the Crime of Aggression against Ukraine, ICPA, which is the first ever international investigatory institution which investigates crime of aggression in case of its real perpetration after the Second World War. So there was not a single case after the Second World War and after the work of the Nuremberg and Tokyo International Military Criminal Tribunals where there would be a common international effort on investigation of the crime of aggression when this crime really took place. So ICPA, which started its work in The Hague July last year, so a year ago, is the first such an effort where Ukrainian, Polish, Lithuanian, Latvian, Estonian, Romanian prosecutors, together with a special prosecutor from the US, and together with the International Criminal Court, commonly discuss the ways to investigate the crime of aggression. So ICPA is a value itself, because, as I said, this is the first effort in 80 years. But of course, we are working for it not only to be the value in itself, but for the ICPA to be the important step towards the establishment of the tribunal. And maybe the final point would be that what we do appreciate a lot, and this is of course very important, the idea and the progress towards the establishment of the special tribunal gets high international attention on expert level, on political level, on the level of decision-making by means of resolutions of parliamentary assemblies of Council of Europe, European Parliament, also parliamentary assemblies of other international organizations. In the end of April, Council of Europe took a very important step in playing the leading role in the establishment of the special tribunal. Currently, the Secretary General of the Council of Europe prepares draft documents for the tribunal to happen, for the tribunal to be established. So this international support is also a crucial element. And this is what we also, I think, succeeded in throughout these 2 years. And of course, we need to keep this international support while we move towards the finalization of this work.
This sounds like pretty impressive work on the tribunal. And I think another important impact of the tribunal like that could have is preventing future similar situations, right? And making sure that there is responsibility for violations of international law international human rights that still exist. Thank you, Anton. And I think also Judge Gnatovsky mentioned about the injuries that are made to international law by way of the invasion. I absolutely agree. And it's often reported in the US news, and I'm sure worldwide, the atrocities that happen in Ukraine. So the Russia's invasion of Crimea in 2014 and later Russia's invasion of the east of Ukraine starting 2022 turned into basically a daily global geopolitical conversation. Has Russia's invasion impacted international law to the point that it's changed now, either altered or tweaked to in a certain area? And what, in your opinion, are the main changes in international law as a result of the invasion? And I guess this question is to all the panelists. If we could start with Judge Gnatovsky.
Yeah, thank you very much, Anna. I think the important part here, perhaps for me, is that we were used to live in the world which was based on a certain order, on the world that seemed to have learned the lesson from the Second World War. The world that had a certain mechanism, at least theoretically, on how to react to threats to peace and violations of peace and acts of aggression. It didn't always work perfectly, but it kind of existed. And then we have a situation which actually casts doubt on the very foundations of that order. Because in that order, on the one hand, we have the UN Charter, we have Article 2, Paragraph 4 of the UN Charter, which in absolute terms prohibits any member state of the United Nations, that is any state, in fact, in the world, to act in the way that is an aggression against use of force or threat of force, the use of force against political independence and territorial integrity of another state. There can be other instances of the use of force. We can discuss endlessly things such as humanitarian intervention, responsibility to protect, God knows what, but none of that is aimed against territorial integrity or political independence as such of the state. And what the Russian Federation is doing vis-a-vis Ukraine is exactly denying it the right to exist independently. So attacking its political independence, essentially asserting that Ukraine has no right to political independence. And then, of course, denying its territorial integrity. That is saying that, well, we will annex this part of the territory and that part of the territory, and in principle would like to annex the whole country. And this is at such variance with the very foundations of that order that this does require action, and this will inevitably change international law, because institutionally, from this sort of mechanical point of view, from a mechanism point of view, the body responsible for upholding international peace and security is the UN Security Council, where 5 states have a particularly important responsibility. And those states are permanent members of the Security Council, and they have the so-called veto right. And one of them is de facto Russian Federation. I mean, the UN Charter says it's the Soviet Union, but the Russian Federation took over its seat, lawfully or unlawfully. It's another discussion. But de facto, this is it, and it blocks. And that's what it showed to everyone in 2022 and after that. It blocks that mechanism. So basically, we are faced with the utter inability of international law to deal with such a fundamental violation. And this will have to be changed, because we will not be able to continue like this, because no state can be secure after that. So, of course, international law will have to change. Thank you.
Thank you, Judge Gnatovsky. Anton, do you have any thoughts about the changes to international law as a result of the war?
Yeah, thank you so much, Anna. Of course, this is one of the most important questions questions, and one of the most sensitive ones, because we understand that changing the international legal order is not the easy task, and it requires political will, in particular of those states who are there in the Security Council of the United Nations, and who try to use also these mechanisms which exist now to do, some of them to do good job, some of them to their benefits. So I think that here, of course, it is seen that the international worldwide security system, which was laid down in the UN Charter, in particular in Chapter 7 on UN Security Council, doesn't work. So United Nations Security Council in the current architecture cannot secure the international peace and security. And in particular, a permanent member of the United Nations Security Council can commit aggression, and there will be no legal responses to this. So this is a possible situation, as of course Judge Gnatovsky mentioned. So I think this is the first issue which we see, that this international peace and security system really should be changed. Maybe as a second point, we may also point out the importance of the United Nations General Assembly. Understanding its limited abilities under the UN Charter in the current architecture, maybe these capacities should be broadened, and maybe United Nations General Assembly may be empowered to do some things, really empowered, not as it seems within different procedures which currently exist. And of course, I think as the second and as a third issue, as a third point, I would mention that this Russian aggression against Ukraine really pointed out the accountability gaps which exist. So yes, international law, international lawyers worked a lot for decades to establish international accountability system. And this is great, and we do have good results of it. But we see that there are gaps and loopholes. And we see two gaps and loopholes in the situation of Ukraine. As I mentioned, the absence of a compensation mechanism and the absence of the special tribunal for the crime of aggression. Maybe in some other situations, there will be more these gaps and loopholes. So I think that the third point is that we need to empower and to work to move forward with ensuring accountability and ensuring that no gaps, no loopholes exist in this system, and that international law prevails over realpolitik. Thank you.
Thank you, Anton. Maria and I also discussed the book, which is quite an interesting, in my opinion, book written by the University of Chicago School of Law professor Tom Ginsburg, that is about democracies and international law. And Professor Ginsburg essentially writes that the world order is currently split, in his opinion, in two human rights or international law orders: the law of democracies and the law of authoritarian governments. But I think that the democracies prevail, and there are plenty of countries all over the world supporting Ukraine. So I guess my question is to Maria, based on your personal vast experience of international law and international relations, would you be able to elaborate on the positions of other governments that you observe with regard to international human rights violations and generally international law in Ukraine?
Good afternoon, everybody. Thank you so much for inviting me. It's a pleasure to be here today, and especially to see my good old friends and colleagues. I must admit it's quite complicated for me to speak after Mr. Gnatovsky and Korynvych have spoken. I was thinking about what else I could add, and still there are some things I could add, hopefully. Anna left for me quite challenging topics for a discussion, because though I'm being a legal advisor at the embassy, I cannot speak in my capacity as an advisor, but I will speak in my private capacity, though my work seriously influences my positions and my views. I I think I will also have to add maybe several strokes on the war of Russia against Ukraine, especially on this truth, and maybe it will also shed some light on what it is important, because to answer your question in shortly, it is really important to stick to democracies and to enhance their cooperation. I mean, this is the only alternative we have, and maybe also in a nutshell, this is what Ukrainians are now fighting for, and this is what they're being punished for by the Russians. In fact, that we choose to become part of the civilized world, of the European family, of Western, so to say, family. And by West, I also, of course, mean not only the geographical part of the world, but it's these are the countries which are surrounded by the same values, and democracy is being one of them. The democracy where people can choose their government, can change the government if they are not happy, where they have human rights and institutions to safeguard them and to protect them. Of course, this world, as Judge Gnatovsky has said, is not always perfect. It has its flaws, but it's the best we can have. And this is like probably the bottom line of what I wanted to say. And the roots of this conflict also is quite difficult maybe to understand in one glance. It is an existential conflict, like Mr. Gnatovsky pointed out. It is an attack on a statehood, on a political regime of Ukraine by Russia. But why is it happening in the first place? I think we need to look back into some history, and of course, I'm not going to give you a history lesson because it might take ages. But just to understand that Ukraine has been independent last century for 2 years. In fact, in 1918, Ukraine had an independent statehood, but unfortunately, the Bolsheviks managed to return it to the empire, Russian Empire, and from that on, they created a class ideology and fake Ukraine under their red flag. And only with the collapse of the USSR, we managed to return our statehood, not the fabricated one by the Russian Empire and by the communists. While Russia could never overcome this, actually, it had lived with the idea that all the former USSR republics are, so to say, temporary phenomenon. And sooner or later, the imperial state, which is Russia, would restore its statehood. First, they wanted to use political and economic leverages, and this is why we had quite a lot of difficult periods during our independence period of these 30 plus years. But their main, and because they tried to keep the future provinces of the Russian Empire on the short leash, and they wanted to prevent them from joining alternative political and military alliances like NATO and the EU. So Russia's transition from political and economic pressure methods to military force was quite predictable, unfortunately. It is because we live in a post-Second World War world where we think that the use of force is no longer a method of international politics. We could not actually believe it until it happened, first in 2014 and then in 2022 as a full-scale aggression. So for Russia, Ukraine as an independent state, which is willing and able to decide its perspectives and its participation in different alliances outside of Russia's scope is a taboo, is something unthinkable. So this is why it is for us it's an existential conflict, and for us it's actually the matter of live or die. I think that this is also partly answers your question regarding democracy and protection of human rights, because this Russia's war is not so much also original as a civilizational conflict, where a democratic state, Ukraine, with all its flaws, which I know it's not a subject of today's discussion, still is waging a war of Russia is waging a war of neocolonialism. And the authoritarian regime, which is personified by Putin, is an example of what happens if democratic states do not stand strong against such regimes as Russia and some other regimes like North Korea, which, as we now see in Iran's regime as well, are becoming a new threat, not only, well, global threat, in fact. I'm not afraid to say so. And this is a task for the whole world. And in my position, the US needs to maybe grasp the idea that it is one of the leaders, actually the leader of the democratic world. And if we don't stand up to this now, it could be, the consequences could be once again quite gloomy for all of us. I hope it answers your question.
Yes, it does. I wholeheartedly agree. I think all of the panelists have families left in Ukraine. From the larger scale, from the international law perspective, when you think about your neighboring state that you had business with a month ago invade your territory, this seems devastating. But from a personal level of somebody who has family in Ukraine, who has grandparents and extended family living there and observing day to day the atrocities committed by a neighboring state, and the victims that have to pay with their lives for the atrocities, I think it goes to a totally different level. It's absolutely devastating, and all the countries of the world should be aware of what could happen to really anyone. In America as a superpower has a say in this as well. We can see that Russia's ongoing war generally in Ukraine has led to a lot of victims, displacement of people, caused loss of life, property, and continues to have a devastating effect on the economy. So I want to transition from here a little bit and talk about the businesses and investors that respond to the challenges presented by the invasion. Alex, can you please talk and tell us a little bit about the claims that were brought against Russia before international courts and tribunals related to the assets and properties and their businesses that were impacted by the war?
Of course. Thank you very much for having me, and I'm glad that we're having this little reunion with Judge Gnatovsky, Ambassador Korynvych, Maria, and you, Anna. We all go back to the same, our first, and I would say the alma mater we hold close to our hearts still. So I'm glad to see you all on the line today, including some members of the audience who I know. My job today is to comment on the situation from a perspective of businesses and private parties. My practice is focused on international commercial disputes and investor-state disputes, and that practice also became relevant in the context of Russian invasion of Ukraine, going back to 2014 when it all started with the annexation of Crimea. And the interesting sort of aspect here, hearing the remarks of my co-panelists, is the timing, because there's a lot of commentary out there that international law is not fit for purpose, is not evolved enough to address the challenges. But we see that international law keeps moving slowly but surely and continues to evolve to address the situation. Right now, we discussed the judgment that came out from the European Court of Human Rights dating back to the events in Crimea in 2014. And a lot of the cases I had the pleasure of working on also sort of the awards in those arbitrations became available only recently. They were issued in the past several years. So the international justice mechanism, I should say, is working, and we can probably expect some results and some outcomes to come that sort of relate to the 2022 full-scale invasion of Ukraine, maybe 7 or 8 years from today, because right now we're in 2024, exactly 10 years away from what took place in 2014 in Crimea. So at that point, interestingly, there were not that many optimists in terms of international law practitioners. And like Ambassador Korynvych mentioned, all the talk about don't do it. Why do you need to work on establishing something that it's hard to establish? And you have so many issues related to consent of the Russian Federation and things like that. That also applied to claims of private parties, individuals, and businesses when the Crimea was annexed. And a lot of commentators said that, you know, it could not be done. You cannot use international arbitration to file claims against the Russian Federation. It has never been done before. And in particular, what I'm talking about is claims filed by investors against sovereign states under bilateral and multilateral investment treaties. Those are basically investment protection treaties available to foreign investors that invest in these countries. And what has not happened before 2014 is that those treaties have never been applied in a situation where the host state sort of voluntarily and on its own attempted to change the scope of its territory by annexing another sovereign territory of another state. So the interesting situation that a lot of Ukrainian and foreign businesses found themselves in, they've operated some businesses in the territory of Crimea, which was the territory and continues to be the sovereign territory of Ukraine. And they overnight found themselves being in Russia, where at least those who occupied the peninsula claimed that Russian law applied in the peninsula, and that they were now subject to a different government and different rules. So at that point, those businesses had choices. Okay, what do we do? And some chose a pretty futile mechanism of filing claims before Russian courts in Crimea or elsewhere. And as Judge Gnatovsky confirmed earlier on the call, years later, we now have a confirmation that actually there was no legal basis for existence of any of those courts in Crimea. So a number of investors, mostly starting with state-owned companies and also, let's say, big businesses who could afford expensive international proceedings, they filed claims under Ukraine-Russia bilateral investment treaty, alleging that by occupying the territory of Crimea and treating it as part of its own territory, Russia accepted the obligations under the treaty to protect Ukrainian investors. So even though investors in Ukraine were not foreign, let's say in January of 2014, after Russia formally annexed the territory of Crimea and even amended its own constitution to say that Crimea is now part of its territory. Those basically through its own actions, Russia confirmed that the territory should be treated as its own, and therefore it should be held liable for failing to protect the interests of investors. So fast forward a number of years, all of the investors that brought those kinds of claims that were novel at the time, they were successful, and by now numerous, I would say about a dozen international tribunals satisfied the claims of such investors, found violations of the bilateral investment treaty between Ukraine and Russia, and held Russia liable, issued awards in favor of investor, ordering the Russian Federation to compensate the investors for the assets that were unlawfully expropriated. Because Crimea essentially was a big land grab and a grab of assets that came with it. What's going on in eastern Ukraine and then south of Ukraine right now is pretty much the same thing. Russia occupying the territory and then just sort of taking all the assets. And in addition to just claims that are being decided on a state-to-state level, it impacts the lives of individuals and businesses. And the big question is, like, what is the next step? Can international law and investor-state arbitration or other mechanisms provide avenues for claims to be brought against Russia. So the investor state route, as I explained, was successful in case of Crimea. At this point, it remains to be seen to what extent it can address the events of the past two years. A number of claims are in the pipeline related to what took place after Russia's full-scale invasion. A number of claims have been submitted to the European Court of Human Rights, and I believe Judge Gnatovsky mentioned the cases pending against the Russian Federation. So because Russia's full-scale invasion predates September 16th of 2022, when Russia ceased to be party to the European Convention of Human Rights, those claims could be filed and continue to be pending before the court. There are other, let's say these two mechanisms, the European Court of Human Rights and investor state arbitration, have so far been the main focus of private parties, but this by no means is exhaustive, and it does not provide relief for many others. I would say the first category of potential claimants are like all the small claims, right? Small businesses and just regular individuals who lost their properties and livelihoods. That there's an effort currently to establish, I should correct myself, it has already been established, the register for damage related to Russia's aggression in Ukraine, which is currently operational, and I believe as of today expanded its mandate a little bit in terms of it started to accept the applications not only from individuals but also from companies and even the state related to damage done to residential properties. And the register of damage is just the first step in that big multi-level process that Ambassador Korynvych mentioned, is filling in the void of a compensation mechanism. So the register seeks to create a database that has all the evidence that can later be used by the compensation mechanism to sort of provide relief to those injured by Russia's conduct in Ukraine. I want to mention an important aspect of how international law sort of develops as a result of events like this. A lot of what has been done on the international arbitration playing field was made possible by the jurisprudence that actually comes from international human rights, and in particular the European Court of Human Rights, because all of these investors that brought claims against the Russian Federation were able to be successful because of the concept of effective control of territory that was developed in the jurisprudence of the European Court of Human Rights, which effectively said that Russia cannot have it both ways. It cannot claim that it's Crimea or any other territories it formally occupied and then it purportedly annexed could be its own territory, and at the same time say that it does not have any obligations with respect to individuals and properties and rights of those in those territories. So later, the European Court of Human Rights was the court that confirmed that Russia had effective control of eastern Ukraine as well, starting from very early, I believe it was around April in 2014. That is one of the biggest sort of issues that come up in these cases, because any investor or claimant before the arbitral tribunal established under the bilateral investment treaty or at the European Court of Human Rights, claimants would need to prove that Russia exercised effective control of the territory. And there's a judgment of the European Court of Human Rights covering the period from 2014 all the way through 2022, let's say a month before the full-scale invasion began. And after that, I believe there's no debate as regards Russia's involvement in the conflict and its sort of ability to control the territories it occupied. So I guess my sort of conclusion of what I wanted, the message I wanted to deliver is that international law does provide certain mechanisms for private parties to hold Russia accountable. At this point, though, a number of awards that were obtained by investors against the Russia Federation are in the enforcement stage, which is sort of a saga of its own. Investors need to chase Russian assets across the globe. But what's important to remember is that we live in a quite dynamic world, and I think a lot of those pursuing these claims, they want these claims examined by any court or tribunal that is legitimate at the time when evidence and witnesses are still around. The time when Russia is actually held accountable, when these decisions will be enforced, that time will likely come later, and it really will sort of depend on whether or not and at what point Russia will attempt to be reintegrated into the international community. Because at this point, it exists in isolation, and we believe that it's not going to be, it's only a matter of time when those decisions will need to be complied with.
Thank you, Alex. This is very helpful. There was a question submitted to Maria and Anton. I think Maria maybe can take that. We have a couple minutes left. Or Anton can. What does the Ukrainian government currently do to collaborate with the other governments that are in the democracies to follow international law and enhance its compliance? And Maria, if you want to take it from here.
Well, yes, thank you. Gladly. Just to make it clear, I'm covering the bilateral relations with the Netherlands. So of course, I'm not in a vacuum and I understand what is happening around. But I would also, I would just flag that Ukraine is trying to resort to any possible venue, forum, institution to defend itself. Of course, here we're talking about the legal field. We're protecting ourselves in the legal dimension, which is quite important because international law is on our side. And we're trying now to restore it and maybe to update it, so to say, respectfully. And of course, this is happening with the help of the international community. Mainly the European Union and G7 states are supporting us. Just recent examples of the international support is I've just flagged out on the 29th of June, quite recently, there was the Parliamentary Assembly of the OSCE, and they adopted a resolution which condemned Russia's 10-year armed aggression against Ukraine, recognizing the actions of the military and political leadership of the Russian Federation and its armed forces during the full-scale invasion as genocide of the Ukrainian people. The OSCE is quite an international organization which counts as its members not only European Union, but European Union states, but other international, but other states as well. Also, Russia has been quite recently recognized as a sponsor of terrorism or a terrorist state by 13 countries. Among them, the Netherlands, which I'm happy to admit, also Parliamentary Assembly of the Council of Europe, which is an organization. It's also NATO Parliamentary Assembly, the European Parliament, and the Parliamentary Assembly of the OSCE recognized this. So it's quite important. This is part of the everyday, probably, work of every diplomat to bring those important messages to the leaders of the world and to understand, to explain why it is important to support this case of Ukraine, which is now becoming more than just a case of war of Ukraine against Russia, but also as I said before, and I hope my colleagues will also support me on this, that it is the existential conflict, and it's a conflict of the Western civilized world against, well, Russia, which is the face of the authoritarian neo-imperialism and neo-Nazi regime, which is trying to enforce on the others the rule of force, well, basically, again, and to demolish the values and institutions that have been built together in the effort after the Second World War.
Thank you, Maria. Anton, do you have a couple words to say on this subject?
Well,
we really have very little time left.
Very briefly. On a daily basis, we work with our international partners, and this work is everywhere, in everything which deals with accountability. For instance, our international partners intervene in our cases against Russia in the International Court of Justice and in the European Court of Human Rights. For instance, our international partners, under the basis of universal jurisdiction, investigate Russian war crimes committed on the territory of Ukraine. For instance, together with our international partners, we work in the International Center for the Prosecution of the Crime of Aggression against Ukraine, ICPA, which I mentioned. Together with international partners, we established the Register of Damage, which Alexander mentioned, and a Register of Damage is an international effort. Together with international partners, we work in the core group on the Special Tribunal for the Crime of Aggression, and core group meets regularly, pretty much every 2 months, in different capitals throughout Europe. So our international partners organize these meetings. So everywhere we feel the support of international partners, but of course it's important that this support continues till our job is done.
Thank you, Anton. And Alex, I have one question to you as well.
If I may, can I quickly just add to everything that was just said? I think it's also important to emphasize that the International Criminal Court is currently hard at work as well, focusing on Russia. There were a number of arrest warrants issued, and I know that there's a pretty big effort currently being done by the court to examine the evidence that was submitted to it. So hopefully that will also lead to some results very soon.
Thank you. One more question to Alex. How does the international law from a commercial standpoint, the commercial international law, evolve in order to meet the modern challenges presented by the armed conflicts like Russia's war in Ukraine?
So I think I briefly mentioned it already in my earlier remarks, is the ability of investor state tribunals to examine claims in the context of annexation, right? And at this point, we are sort of a number of cases that arise related to the events of the past 2 years. Those cases are still in the pipeline, and we don't know how the situation is going to develop there. A number of claims are pending before the European Court of Human Rights, and we understand that both those routes lead to a problem of enforcement, right? So the ultimate question is, once you get the arbitral award, if you're an investor that has a qualifying claim protected by the treaty, or you are a claimant, a petitioner that could submit its claim to the European Court of Human Rights, what lies ahead, right? And at this point, unfortunately, it's unclear how and with what level of success those awards can be, and awards and judgments could be enforced. However, the law itself, the international investment law at this point, was enriched by a number of awards, that a number of them are in the public domain already, where the tribunals had to grapple with very novel issues of international investment law and the application of bilateral investment treaties in the context of annexation and armed conflict. So there's a continued reliance on the jurisprudence of the European Court of Human Rights and other human rights courts. That's also how the law keeps evolving. And I'm sure that the effort at the International Criminal Court will lead to sort of a completely new chapter. Because those gaps that Ambassador Korynvych mentioned, and just general, like the gaps that exist for private parties and claimants, they should be filled. Like if existing mechanisms under international law are pursued actively, sort of the international community is going to be pushed through political efforts, through advocacy efforts, to create mechanisms that are going to eventually fill in the gaps. So I think it's very much an ongoing process, and it's incorrect for people to expect results soon. The situation in Ukraine is very disturbing, but it's important to sort of believe in international law and to work on all fronts. Because as I believe Judge Gnatovsky mentioned in the beginning, Ukrainians find itself on the right side of history, and they chose to pursue the legal routes and sort of to operate within the rule of law realm.
Thank you, Alex. I would like to thank all the panelists for finding the time in their busy schedules to attend this webinar and present their thoughts on the implications of Russia's war against Ukraine. We'll continue to observe the developments in international law as they transpire. We're out of time, but we appreciate your attendance. And for now, Slava Ukraini.
Героям слава.
Love
Thank you.